defendant's motion.
I know.
Yes.
Defense is ready to proceed.
Yes, Your Honor.
Yes, Your Honor.
Okay. First witness.
And Your Honor, we would like to invoke the record, please. The rules.
Yes, ma'am. State, you need a moment. Defense, you need a moment, either side, to inform your witnesses.
Yes, Your Honor.
Okay.
Well, Judge, the only witnesses present at this moment are members of the bar. They know the drill. I don't know that the.
Well, I don't know if any are outside and will come in. I always see Mr. Messore standing
Ms.
up.
Fitz George is here. Mr.
We'll let you go
Mummert is
instruct
here,
them
Mr.
anyway.
Messore.
Yes, ma'am. You may proceed and then we'll get going. How's your weekend?
I worked on Saturday.
Oh, did you?
Yeah, that was fun.
Oh, you so you're here for the guest appearance.
I was,
Oh, that's,
although not in court.
oh.
I certainly read it.
It didn't matter, it was on the iPad.
That's what Candace said.
It was anti-climactic.
Glad it wasn't me.
Yeah.
How you doing? All right. Oh, I'm sorry to hear that. I've got some decongestants in the back if you want one. Oh, okay, all right.
Ready to go, Your Honor.
State's ready as well.
Yes, Your Honor.
Okay, first witness.
We will first be calling Miss Kathleen Fitz George.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Morning.
Good morning.
Good morning.
Can I trouble you to state your first and last name?
My name is Kathleen Fitz George.
And Miss Fitz George, you were not on Mr. Mark Sievers' defense team, were you?
No,
Well then, who did you represent, making you relevant for today?
I represented Jimmy Rodgers.
Okay, and Mr. Rogers' relevance to the legal matter we have pending today is, question mark?
He was the defendant in the indictment,
Okay, so co-conspirator with Mr. Mark Sievers.
allegedly.
Okay. Now, I guess, were you on Mr. Rogers' case from its inception? Did you come on at some point during its development? Characterize your role generally, please.
I received a call from his family in Missouri and then set up a phone call with Mr. Rogers while he was still in Missouri. So we were on it from the start.
Okay. And I guess as an initial matter, because I'm sure this will become relevant to your responses as we go, has there been a waiver of Mr. Rogers' attorney-client privilege regarding the work you did for him on
Not
this
that I'm
case?
aware of, no.
Okay. So, in the course of working on Mr. Rogers' case, did you work with Mr. Sievers' defense team?
Yes,
Okay. And with whom did you work? Can you name them, please?
Michael Mummert.
Okay. And was there also Mr. Gregory Messore?
He came on later and didn't really work. He didn't appear very often.
Okay. And I guess, did you have an understanding of what his role was within Mr. Sievers' defense team?
Not a full understanding. I mean, he was capital qualified, was my understanding, and he would be present for trial, involved in penalty phase, but also in some of the trial hearings and whatnot, and just the case overall. I'm not sure how you'd have to be involved in the whole thing to really.
Okay.
show
You
up.
mentioned he's capital qualified. Why did you mention that?
Because it's a capital case.
Okay. Is that relevant in the context of any other individuals on Mr. Sievers' defense team?
At the time, Mr. Mummert was not capital qualified to the best of my knowledge.
Okay. And you know between Mr. Mummert and Mr. Messore, who was first chair for Mr. Sievers' trial?
Mr. Mummert was hired by Mr. Sievers. He took the lead, certainly, with the trial phase.
Okay. And I guess to understand the degree of your insight into the Sievers defense team, did you have an opportunity to work with them kind of in the trenches as the case was being litigated in the pretrial phase?
Yes,
Okay.
extensively.
You said extensively?
Yes.
Okay. Can I trouble you to expand on that? How would you, I guess, characterize it beyond extensive?
Well, I've known Mr. Mummert for many years. I was his supervisor when he was at the public defender's office. And, you know, I've watched him come up through the years and handle a variety of cases. Though he was a good lawyer and, you know, we're friendly. I was friendly with his wife at the time, who was also part of the team. Their investigators, our investigators that they used, the Olsons, were investigators that I use on different cases as well. So between my team and his team, yes, we were together a lot. All the depositions, we coordinated them, took them all together, and they were extensive. There was a million of them, it seems like.
You mentioned having worked with Mr. Mummert previously. Yes, how are you currently employed?
I'm the Chief Assistant Public Defender for the 20th Circuit.
And how long have you been with the Public Defender's Office?
35 years.
And prior to the Rogers Sievers cases, had you tried, or I guess how many capital cases had you tried?
Prior to that case, 4. So at this point, 6 I've tried, I've handled. I don't know how many, but many of them over the years. I started very young in my career, working on capital murders. And then I went on to run the homicide division.
Okay. In order to get that role, besides trying a number of capital cases in various capacities, are there any other trainings or educational components that you have to complete?
When I began, there was no such thing as being a capital qualified attorney. Someone walked down the aisle, the row where my office was, and said, "Hey, we need a skirt on a murder case," and I just raised my hand and said, "Okay." Now there's a lot of different, to be capital qualified, you have to handle so many trials, so many complex cases, so many homicides, trainings. You have to have at least, I think it's 12 credits every 2 years, specifically in capital defense work.
Okay, and when you say so many credits over such a period of time, would those be continuing learning
Yes.
educational requirement credits?
Yes.
Okay, and so you obtain those credits by attending specific death penalty focused seminars?
Yes.
Okay. Now, were Mr. Rogers' case and Mr. Sievers' cases tried together?
They were not.
Okay. Why not? Or I guess procedurally, why not?
Procedurally, I felt our chances, our best bet was to proceed without them together. This was a massive case, and I kind of felt that the last thing we needed was to sit in a room where Mr. Sievers would be pointing the finger at Curtis Wright, of course, but also Jimmy Rodgers. So when it came down to it, we were ready to go, and we wanted to get in there, and Mr. Rodgers was ready to go. So that's what we did. We just thought it was the best course of action for our client.
Okay. One of the things you mentioned, concern for at whom fingers were being pointed in the course of a trial. Was there anything based on your work with the Sievers defense team that gave you specific concern that could be a component of the trial?
No, just based on my experience. I mean, you have to point the finger somewhere, and Mr. Wright was not, his statements, he had given 4 statements and 2 proffers. There was a lot of them. There was a lot of inconsistencies in there that we felt we could capitalize on, but he was no friend to our defense. So then if we were trying them together with Mr. Sievers' case, we just thought, let's just eliminate that aspect of it, Mr. Sievers' aspect, in terms of testifying.
Let me ask you to explain something that I think I heard you say. Mr. Sievers was no friend to our defense. Can you explain that a little bit? To the extent that you're able to with privileges still being in effect.
Well, we felt that we had a pretty solid defense in terms of, excuse me, Mr. Rogers' involvement, or lack thereof. And Mr. Rogers and Mr. Sievers didn't really know each other. I mean, they had met, whereas Mr. Wright and Mr. Sievers had been close friends for many, many years. They kind of grew up together. They went to school together. We felt that, and also Mr. Wright was a little bit of a loose cannon in terms of, I mean, here was a man who, in our opinion, who strived to look like Mr. Sievers, who was a little obsessed with him. We didn't know too much about the background in that because we didn't have Mr. Sievers' side of that, so we wanted to really kind of avoid that. Our strategy had been, our client got in a car and came to Florida. He never saw the ocean when he come down. He plugged in his GPS, text on the way with family. He took pictures. He went to the beach. He took presents home for his girlfriend and children.
I'm going to interject, and I apologize for interrupting. So we did see the ocean.
Well, he saw the Gulf of Mexico.
Okay.
Gulf of America.
And ocean. Okay. So I guess I want to make sure I understand it. Concerns for any potential finger pointing from the Sievers camp towards your client was based on your experience regarding things that can happen in co-defendant trials rather than any concrete specific information you'd received from
Correct.
Mr. Sievers' defense team.
Correct.
Okay. Now, you characterized Mr. Mummert's work and overall role in the case as, I guess, maybe you did it, and I'll ask you to do that now. How would you characterize it?
Very thorough.
Okay. And you indicate that he wasn't at the time death qualified. Did you observe anything that in your professional perspective was an indicator of that when you were watching him work? Was there anything you said, oh, I wouldn't have done that?
No, nothing.
Okay. Would you say the same thing about Mr. Messore?
No.
Okay. I guess, how would you characterize Greg Messore's influence on how the respective cases developed?
I don't think he had much influence. He was largely not present. I don't think he showed up at one deposition. We had a lot of hearings, motions, court events. I mean, maybe a handful of times then, but at most. So I didn't have any real relationship with him. So.
Okay. Yes. In the course of the extensive collaboration with Mr. Mummert, you never had an opportunity to also collaborate with Mr. Messore?
I didn't collaborate with him. No.
Okay. And I imagine during Mr. Rogers' trial you weren't picking out every face in the audience, but do you, recall whether or not Mr. Mummert attended all, some, any of the days of trial for Mr. Rogers?
He did attend. Some, many. Yeah.
Can you recall whether or not Mr. Messore attended?
I don't recall. I don't recall him being there, or I don't recall looking for him. He wasn't someone I interacted with on the case at all.
Okay. So I guess let me make sure that that response is accurately characterized. You weren't necessarily looking for him, but to the extent that you did any looking, you did not see Mr. Messore.
Correct. I saw a lot of the rest of Mr. Sievers' team in the courtroom.
Okay. Hold on one moment, please. Those are my questions for now. Thank you.
State.
Good morning, Ms. Fitz George.
Good morning, Mr. Hunter. This is unusual, huh?
Different look from up there, isn't it?
Yes, it is. I don't think I like it.
It definitely gives us some perspective as trial lawyers.
Yes.
So, Ms. Fitz George, I didn't hear defense ask you, how many death penalty cases have you tried?
I've tried 6.
And these
now,
were,
so as of this year, so.
and these were cases where death was a possible outcome of the trial.
Yes, on at least one of them, death was, well, you were there, death was waived, very close to trial. So, but it had been a factor throughout, so.
One in Hendry County.
Yes.
And after a trial, how many of those cases ended in a sentence of less than death, including the one we had in Hendry County?
All but one.
All but one. Congratulations.
Thank you.
So it's safe to say Mr. Mummert was well-trained when he was an assistant public defender.
I think so.
Mr. Mummert was trained on the fundamentals of criminal defense law.
Yes, we worked together when he was on the Judge Reese track that I ran quite a few years ago. So.
And is it safe to say that many of the pretrial hearings that happened in the Rogers and Sievers cases all happened at the same time in court?
They did, yes.
Were you present for the hearings that were conducted in this courtroom regarding Mr. Mummert's and Mr. Fega's qualifications?
Yes.
And you recall Mr. Sievers waived no qualifications. You recall that?
I remember there was a question by the judge asking Mr. Mummert, are you capital qualified? No. Well, do you have someone? Do you talk to someone? He said, well, Ms. Fitz George. So I do recall that.
Do you recall the court offering Mr. Sievers death qualified counsel?
I do.
And Mr. Sievers opted to stay with Mr. Mummert. Isn't that correct?
That's correct.
Is it safe to say that you don't know what Mr. Messore did in preparation of their defense
Correct.
or mitigation?
Correct.
Were you present for the penalty phase of the Sievers trial?
Some of it. I don't know. I don't recall that I was here for all of it.
And in fact, Mr. Messore led the penalty phase, didn't he?
He did.
And we talked earlier about your decision, which was kind of also I'll say a 10th hour decision in the case to move to sever Mr. Rogers from Mr. Sievers.
Correct.
That was a tactical decision, right?
Correct.
You made a reasoned and legal decision to protect your client.
Yes.
And the court, you said earlier that you hadn't yet received a waiver, despite the fact that your team not only defeated the death penalty for Mr. Rogers, but also secured convictions on lesser counts. Are you aware that he filed a 3850?
Objection, Your Honor, relevance.
Overruled.
I did see one in court file, yes.
And he's alleging ineffective assistance of counsel on part 5 of his claim,
Sure.
despite what you did for him. If ordered to waive privilege in that hearing, will you waive then?
I would.
Mr. Mummert's preparation in this case was thorough.
Yes.
You wouldn't have prepared any differently.
No, I mean, you always want more time. I think we filed a last-minute motion for a continuance each time. We were set for trial twice. There's always more to do. The last place you want to be on a death penalty case is in front of a jury, frankly.
And if you were Mr. Messore, you would have been present more often.
I would be, yes.
You also didn't file for a change of venue in Mr. Rogers' case, did you?
No, did not.
Now, at some point after Mr. Rogers' trial, one of the issues that's here before the court is a letter that Mr. Rogers sent to, I believe, Mr. Sievers' mom
Yes.
in the end of December of 2020. I think we were still in trial. We might have still been in the penalty phase of this case. Mr. Rogers in his letter, told Mrs. Sievers some things.
Yes.
Objection, Your Honor, this is getting inside the scope of direct.
State.
Judge, well, it is a little bit beyond the scope of direct, but it has to do with her expertise. It has to do about whether or not this evidence is truly newly discovered evidence.
Sustained.
And despite the fact that you felt that there was some antagonism between your defenses, not the defense teams, but your defenses may have been antagonistic to one another, you didn't have any problems conducting depositions and doing hearings with Mr. Mummert and his team.
No, not at all.
And in fact, Mr. Mummert had a team, right?
He did. A team of non-lawyers.
Correct. Investigators, as well as a legal assistant and whoever else he had sitting back there with him.
Yes.
Thank you.
Any redirect?
Briefly, Your Honor, thank you.
Yes, sir.
Whether originally on direct or through cross, you'd indicated that Mr. Messore could have been more present. Is that one kind of accurate reflection of what you said?
Objection. Counsel's mischaracterizing the testimony on direct and on cross.
Sustained.
Based on your observations of Mr. Messore's relative level of activity on the case as you were able to observe it, could Mr. Messore have been more present?
I think the answer would be that if I was him, I would have been present.
Why do you say that?
I would, if I'm counsel on a case, I'm going to move heaven and earth if someone's life is on the line to be present.
Okay. And believe you'd indicated that Mr. Mummert had kind of an entire defense team working with him. Is that accurate?
He had what was then his wife who ran his office. She would help organize the massive amounts of discovery. There was a lot of organizational aspects to it. And another assistant, and then the 2 investigators. So.
Can you recall whether or not Mr. Mummert had kind of consulted with you regarding, what is a satisfactory makeup of a defense team in such a trial?
I don't. I will add that our team, we had a paralegal and an intern, but our team was made up of lawyers in an effort to get other lawyers capital qualified. So normally we would have 2 people on a team. We had 4 because of the necessity to become capital qualified.
Why do you make that point?
Because going to trial with 4, or as in my last trial, 5 lawyers probably isn't a great idea.
All right. One moment, please.
Yes, sir.
All right. That will do it for me. Thank you, Your Honor. And thank you, Ms.
State.
Fitz George.
Just one question. Regarding Mr. Mummert's qualifications, Mr. Sievers has the right to hire the attorney of his choice, right?
Yes.
That's his right to counsel, correct?
Yes.
And that is something that we should respect.
Yes.
Thank you.
Is this witness to be released or retained? State? Agree?
Agreed.
Thank you, Ms. Fitz
Am I
George.
free to sit in the courtroom then?
Absolutely. You've been released. Next witness.
Michael Mummert.